So getting down to business, we'll just, on behalf of the bank officers and board of directors, we thank you for joining us today. We do have some board of directors with us today: Gary Lathrop, John Jorgensen, Dave True, our bank president, Greg Dixon, back there. So we just welcome you to our presentation. Just some housekeeping. There's an evaluation form in front of you that we'd appreciate if you could take time to fill out before you leave today. And so our topic is, are your assets titled appropriately for your estate plan? I'm Kevin Morgridge. I'm the Senior Vice President, Trust Manager, and this is Jennifer Rohr, Vice President of Personal Trust. And our goal today is really to discuss the different ways that you can title your assets, how you can hold title, and how that transfers upon your death. Now, everybody's estate plan is unique to them, and so only you can kind of weigh the pros and cons on how to title your assets and how they'll transfer. And we'll just kind of talk you through how that works. Jennifer and I have worked many years administering trusts and estates. We don't give legal advice or tax advice, and so today we do have Andrew Byler from Lenhart Mason and Associates, and we have Thomas Shaner from Shaner Law, and they will be joining us after the presentation for the question session to answer any general questions that you may have, and so we appreciate them being part of our team. Trust officers do work closely with attorneys and CPAs, and we try to provide a financial planning network to our clients so that you can achieve those estate planning goals. So a little bit about Hilltop Bank and the Trust Department. We are locally owned, and the True family purchased us in 1977. And the Trust Department was chartered in 1984. And currently, our Trust Department has $1.4 billion assets under management. We are a corporate fiduciary, and we're a full-service trust department. So we do trust and estate administration, we do investment management, and we do retirement plans for both individuals and employee-sponsored plans. There's 18 employees, and we do everything in-house right here at the main branch. In addition to Jennifer and myself, there's 7 other officers in our department. And, our goal is to, help you get started on your estate planning, to help you revisit that, and we're always available if you want to come visit with any of us down at the main branch. So what we're all here for today is, what makes up your estate? And so what we want you to think about is, you accumulate stuff during your lifetime. And so all of these things are going to be what makes up your estate. And they don't necessarily have to all be titled the same way. You can own your home one way. You can have a designation beneficiary on your retirement plan. You can have, an account that's solely in your name. So it doesn't mean that everything's titled the same. But what you want to pay close attention to is how they're titled is going to dictate how they transfer. So what we want you to think about is, if something were to happen, and I have this titled this way, how is it going to go? Is that the way I want it to go? So just something to think about what makes up your estate. So why is the titling important? Well, just for those reasons. It determines, your ownership during your lifetime, but it also dictates, how it's going to transfer, who it's going to go to, and when it's going to go to those individuals. So I'm going to turn it over to Jennifer, and she's going to kind of walk us through all of the different types of titling.
Okay. Can everyone hear me okay? Okay, so the first type of asset titling I'm going to discuss is sole ownership. And this is when you own the property individually in your name, and you have complete access to it during your lifetime. At your passing, any property in your sole name will distribute according to your will. And if you do not have a will, it will distribute per state statutes. In this type of ownership, you are subject to probate. And probate is a formal proceeding detailed in state statutes that determines the validity of your will and how your probate assets will transfer. So when you pass away testate, meaning that you've passed away with a valid will, the first step in the probate is your will will be filed with the court. The court will then appoint the executor or personal representative that you've named in your will. And you may not be aware of this, but in the state of Wyoming, the executor or personal representative that you've named in your will to administer your estate must be a resident in the state of Wyoming. And so a lot of times this is where the bank will be named as the personal representative under your will because your children have moved out of state. You need someone local to administer your estate and someone that you trust. But once the executor or personal representative has been appointed by the court, the personal representative is in charge of gathering your assets, inventorying your assets, of getting them appraised, making sure all of the public notifications and court filings have been submitted in the timely manner that's stated in the state statute. The personal representative is in charge of all of the reporting of income, expenses, making sure all your final tax returns have been prepared and filed. And then the assets will distribute per your will upon court approval. There are fees associated with the probate, and it can be a lengthy process, and I'll get further into that through these slides. Some of you may be familiar with or remember Florence Joyner, she was an Olympic track star. And she passed away unexpectedly, and no one in her family could locate her will or her estate planning documents. So there became some feuding with the family, ended up in the courts, and the court appointed an executor that was able to settle her estate 4 years after she passed away. So the point of this example is when you have estate planning documents and you execute them, make sure they're in a safe, accessible location that someone knows where they're located, because also the person that you've named to administer those needs those documents to begin the administration process. So a lot of times you think of your safe deposit box as being the secure place to put your documents, but you want to make sure whoever you've appointed can access those documents because they need them to get the powers to administer your estate. Nice service that Hilltop does provide is when we have been named in our clients' documents, we do have a standby file that's locked, fireproofed. Family knows to come to Hilltop if something happens, and we'll be there to help administer that. So when we talk about, or when you hear the term intestate, that's when you've passed away and you do not have a will. And it goes through the same public probate process as if you did have a will. The difference is that you didn't name a personal representative or an executor to settle your estate. So the court will appoint an executor or personal representative. And I think the biggest difference is the final disposition of your assets are going to go per state statutes. You didn't detail that, so it is going to be determined by state statutes. And to give you an example of what is in state statutes, if you're married and have children, half of your estate will distribute to your spouse, and half of your estate will distribute to your children. If you're married and do not have children, 100% of your estate will go to your spouse, and then it continues on down the family line. So this is something, if you had not intended this to be the way your assets are distributed, it's just really important to be planning and thinking about how are your assets going to transfer. When we talked about that the probate process can be a lengthy process, and that's just because we have a lot of filing requirements. A personal representative has to follow the state statutes, which the first part, when the will is filed with the court, then there's a public notice that is in the paper, published for 3 consecutive weeks, notifying that there was a probate open, allows anybody to contest that within 90 days, and it also opens up to your creditors to file a claim against your estate within 90 days. And I talked about the personal representative has to gather and inventory your assets. Well, they have to inventory and appraise those assets within 120 days because that has to be filed with the court in 120 days. And depending on the type of assets you own in your estate, There are requirements for publications, and everything must be approved through the court. But if you have personal property and it's going to be auctioned or a public sale, there has to be a notice published in the paper that there is going to be a public sale, and that has to be approved through the court. If you have real estate, or real property that you're wanting to sell, that also has to be submitted to the court for approval prior to the sale. And each time that you want to sell or transfer any assets, it has to be approved by the court, but there also has to be notice to the heirs. So it can become a lengthy process. And as long as I've been administering estates for the trust department, I have not seen a probate that was closed under a year. It's usually a year or longer, and it's really depending on the type of assets that are held in that probate. When I talked about the fees associated with the probate, and this is actually detailed in the state statute. And so again, when we talk about probate assets, those are just the assets that you owned in your individual name. And when it was inventoried, what was the value? And in this example, it's $500,000. And so based on the calculations stated in state statute, the attorney would get $10,350. The personal representative would get $10,350 as their fee for administering the estate. And there's a lot of work that goes into that. But as well as that, we have the ability to petition the court for any extraordinary fees on top of that. But just so you know, the cost that would be associated with a probate. And there has been number of surveys conducted over the last few years where 55 to 65% of the Americans reported that they do not have a will. And then on top of that, 8.6% of Americans have reported that they do have a will, but it's out of date. And so almost 2/3 of the American population has a plan that they might not have intended. So it's really, really important to be planning, reviewing your estate plan, making sure it's still relevant and valid. And just for an idea that Whitney Houston passed away, when she passed away, her will was 20 years old. And in her will, she left all of her assets to her daughter. And when she passed, her daughter was suffering from substance abuse. And so had Whitney been reviewing her estate plan over those 20 years, as she'd gained wealth and the changes in her family life, she might have done a different estate plan, maybe created a trust. There's all different types of estate planning techniques that she may have used. But the importance is that you always want to review your estate plan. It's always going to change because life changes, your asset changes. So that's really important when you're planning and looking at your assets. In the state of Wyoming, again, when the property that you own individually, and if it's valued under $200,000, there is a simplified probate process. Another type of ownership is joint tenancy with the rights of survivorship. And this means that you own an equal share with one or more individuals and in joint tenancies with survivorship. So in this case, you have access to 100% of that asset during your lifetime, and so are the joint owners, and it's also subject to all the creditors of the owners. So in an example, if Kevin and I had joint ownership with the rights to survivorship, an investment account where we both contributed 50% into this investment account, but during my lifetime I could take out as much, but if I predeceased Kevin, that transfers 100% to her at my passing. And she's not required to pay any of my final expenses or my funeral costs because that asset's now transferred to her. What we see a lot is that with aging population, or when you're aging, you're thinking about who's going to pay my bills if something happens, or if medically, who can take care of it, who can access my accounts. So we see that children are put on as joint owners with rights or survivorship so that there's somebody that can access those funds and needed. The risk that you might want to consider with that is that now they're 100% owners, so they have full access to that. If they didn't contribute to that ownership, if you created a gift, and it might have unintentional tax consequences that you would want to think about. But they have complete ownership of that account too. So that means their creditors, or if they were going through a divorce, or that account is now subject to their creditors. And so there's things when you're changing ownership or changing titles on accounts and your assets, you want to make sure that you're working with your professional team. You visit with your attorney, your tax professional, your advisor, to make sure that when you're transferring these assets or titling them, you're not creating unintended consequences. For example, you might have named one of your children on as the survivorship because they're here locally and it's convenient, they can access it and take care of you. But at your passing, you really wanted your assets to be divided amongst all your children. But now you've changed that plan by adding them as a joint owner, because that transfers 100% to them and doesn't get divided amongst your children. So when you change title, or when you're titling assets, you just want to make sure that it is appropriate for your plan. Another type of ownership is tenancy in common. And this is where you can own an equal or unequal share with one or more individuals. And this does not have the survivorship feature. So if I had the example where Kevin and I owned an investment account, but now it's tenants in common, when I pass away, or if I predeceased term, my share does not pass to Kevin. It will go down to my estate, and will distribute according to my will, or if I don't have a will, per state statute. This you might see as common is if siblings inherit property from their parents and they want to own it tenants in common so that their share continues on to their descendants. Just something to be. There are risks with titling assets. I can sell my 50% at any time without the consent of Kevin, or my creditors can come after my percent and maybe force a full sell of that property, and that might not be the intention. They can only get my 50%, but they can force sell, or Kevin can become a joint owner with my creditors, and that might not be an intended. I'm sure it probably wouldn't be intended, but another type of ownership is tenancy by the entirety. Now, this isn't recognized in all states, but it is recognized in Wyoming. And this is an joint ownership between spouses. And this has that survivorship feature where if I predeceased my spouse, he would get the property. But during our lifetime, we have to both consent to sell that property. He couldn't sell it without my consent. And it does provide some creditor protection. Community property is another type of ownership. There's 9 community property states with 2 that opt in, Alaska and Tennessee. Wyoming is not a community property state, so I'm not going to spend a lot of time on this slide, but I do want to make you aware of this type of ownership. And this is between spouses. Once you're married, anything that you've acquired or earned during your marriage is owned 50-50 between the spouses. A revocable trust is something that you create during your lifetime. It has a detailed set of instructions for during your life, if you become incapacitated, and at your passing. So you have full access through it during your lifetime, but at your passing, it'll distribute per the terms that you've outlined in your trust document. It's a private matter. These are not filed with the court, so you're not subject to that probate process. And Kevin here will be going into those in more detail shortly. So we've talked about different types of ownership, and there's also beneficiary designations. That's important with your estate planning. And so you may be familiar if you have a 401k or some type of insurance product where you've had to fill out a beneficiary designation form where you've named a primary beneficiary, contingent beneficiary. So just kind of like that joint ownership, that when I pass it, transfer it out to the joint owner. In this case, it'll transfer out to the beneficiary. A real difference there, though, is that the beneficiary does not have access to those assets during their lifetime. And you can change your beneficiary designation at any time during your life. And it'll transfer out at your passing, and it avoids that probate process. Something that you may want to consider again when you're reviewing these forms, and something that's common that we see in the field, that the owner has named a spouse as the primary beneficiary. There's not a contingent beneficiary listed, and the spouse predeceased the owner. And so when the owner passes away, it goes to the state, distributes to the estate, and goes through that whole probate process that we've just discussed. So it's really important, as all of your estate planning documents, is that you want to review them and make sure that they're still valid and relevant for your estate planning. The acronyms you might have heard are TODs, PODs. They stand for transfer on death or payable on death. And these are beneficiary designations for investment accounts, checking accounts, savings accounts. But it's the same transfer at your passing. You'll transfer to the beneficiaries you've listed. Something you might want to think about is when I talked about with the joint ownership, that Kevin, when I pass and that asset transferred to her, she's not responsible to pay my final expenses or my funeral costs. So if you've named all of your assets with a joint ownership or a beneficiary is named, those individuals aren't responsible to pay for those costs. So when you're doing your planning, you might want to be thinking about who's going to take care of my final expenses and my funeral costs. Another type of beneficiary designation is that Wyoming does have a transfer on death deed that transfers the real estate at your passing. So I've gone through different types of ownerships and beneficiary designations. I'm going to turn it back over to Kevin to go in more detail about trusts.
Thanks. So if you're thinking about establishing a trust, what a trust is it's just a document that should be specifically tailored to your needs. During your lifetime, you can establish a revocable trust, and what that is that you can amend it, you can change it. So if you have one and 5 years down the road when you're revisiting your estate plan and you've had some changes, you can go ahead and make those changes. You can actually revoke it in its entirety if you want to. You can also establish an irrevocable trust during your lifetime as well. And this is an estate planning tool to get some assets out of your taxable estate during your lifetime. The other type of irrevocable trust, now this is a testamentary trust, and this trust will be established through your will. So you do your will, and at your passing, then this trust is created differently than the first two that I mentioned. So because this is created through your will, it is going to be subject to probate, just as Jennifer was taking you through that process. But the difference with this is when you go through the probate, everything distributes outright. When you have it in this testamentary trust, you can actually dictate a little bit further on the terms of how that transfers out. So you could create this trust that goes on for generations if you wanted to. So you have a little bit of flexibility there, but it is still subject to the probate process. So when you think about your trust document is really just detailed instructions that you have left in place for your trustee to administer. So Jennifer was talking about how the trust has 3 stages. It's during your life, it's during incapacity, and it's at your death. And so I kind of use this 3-legged stool up here as an example, that the trust is actually going to have 3 roles as well. So you look at that as one leg of the stool is the grantor. You've got to have someone who establishes that trust document. The next leg of the stool is going to be the trustee. You have to have someone that is going to administer that document. It's going to follow the terms that you've set in place. And then the last leg there is going to be the beneficiary. Somebody has to get some benefit from that trust. So if you have a revocable trust, that role can all be the same person. So if you have your own revocable trust, you can be the trustee and the beneficiary and, the grantor. But it's just like if I took one of those legs off the stool would fall. If you take one of those roles out of the trust is not going to be able to operate. It will fail. So some steps of what you think about in establishing a revocable trust is you need to, develop a plan with your team of professionals. Meet with your legal advisor, your tax advisor, your financial advisor. It takes a lot of thought to come up with what you want to do, and it's usually not a pleasant thing to think about dying, but you want to think about what is the purpose of this trust? Why am I creating this? Do I want this to go to grandchildren? Do I have a blended family where now I have a second spouse and I want them to be taken care of during their lifetime, but when they pass, I want my children from my first marriage to get the remainder of my assets. So everybody's going to have a specific purpose of why they want the trust. And then what you need to think about before you start drafting that is who's going to be the trustee? Who's going to be your successor trustee? And you can name an individual, you can name a family member, a friend, and you can name a corporate trustee like Hilltop Bank is. And so you really have to think about who is going to carry out those wishes for you the way you would like to. So once your attorney typically has drafted your document, you'll review that document to make sure that what you have talked about is really what is in there. This is how it's going to work. My plan, this is exactly what I want. This is how it's going to go. So once that is appropriate, and then you execute it. And executing it just means that you need to sign and date that document after it's done. But that's not where it stops. Once you get that in place, that doesn't mean that now you have a trust and everything's wonderful. You have to take that next step, and titling stuff into the name of your trust is the most important step. So if you want, you go back to that first slide that I showed you on estates, and it has all those assets that make up your estate. You look at all of those. My house. Do I want my house in my trust? I do. So I'm going to have to draft a new deed that transfers it from me to the name of my trust, and I'm going to have to record that deed. Complete that transfer into my trust. The same with your investment accounts or anything that you want to fund that trust with. You actually have to transfer title to the name of the trust. Now remember, if you have a revocable trust, you have the ability to change things. Just as you put things in, you could take things out. So you still have some control with that revocable trust. But you want to make sure that you are funding the trust, and that just means titling those assets in the name of the trust. So here are some examples, real life examples. Michael Jackson. Now, he died and he had a trust set up, but it wasn't funded. There wasn't anything in the trust. Now everybody knows what a private person Michael Jackson was, and so for his trust not being funded, it created a probate estate. And so now something that he probably would have liked to be private is public. So everybody got to see what happened in his estate. Another example is former First Lady Jacqueline Kennedy Onassis. Now, she had a very detailed, well thought out plan. And she put a lot of time into this, and under her will, she was going to create this charitable lead trust that was going to save on taxes. Well, the charitable lead trust was never funded, and so therefore it created a lot of tax to her estate, and her estate actually depleted, and so I'm sure that wasn't her plan. It did not work out according to her plan. So both of these are things where people had things in place, but all of the moving parts weren't working the way they should have. So there are the three stages. The next stage of having your trust is if you become incapacitated. So what the revocable trust does is there's continuity there. So you have already decided who your successor trustee is going to be. So you've got someone you trust. You've already spelled out everything that you want to have happen. It's in your document. So if something happens to you, that trusted person or corporate trustee is going to step up into that role and become the trustee. They're going to act on your behalf. There's going to be continuity in your investments. They're going to pay all the bills, and it's just like it continues on. But if you didn't have a trust, now there's options at your incapacity without a trust, and one is that you have a conservatorship appointed. Now the court has to appoint the conservator, and the conservator would get an inventory of the assets, and they'd file those with the court. And then they'd have annual court filings too that show the income and expenses and all the transactions throughout the year. And so this is public record, but this is one way of taking care of you if you were incapacitated. Another option would be is to have a durable power of attorney in place, and that doesn't require any court supervision. But once again, you know, it's like a broken record here. You want to make sure that you are revisiting those, because if you do powers of attorney and you let them sit for 20 years, they may not still be the way that you want it. And here's an example here that Mr. Smith divorced and he didn't update his estate planning documents. And so his ex-wife still had power of attorney and was the beneficiary of his estate. So in the end, when he went into a coma, she pulled the plug. So you just want to make sure that you are, you know, keeping on top of these things, because it's these little details. So the final stage of the revocable trust is at your death. And, you know, that's when, there again, your successor trustee, if they're not already acting on your behalf, will step up and administer your trust. And they're going to follow all of the provisions that you have put in that document that are specific to you and your family and your goals. That is a private process. There's no court filing, so it's generally faster. It avoids that probate process. And but just because this is the final stage of your trust, it becomes irrevocable at your death, but in there you can have provisions that create new trusts. And so new trusts can start from here and go on for generations. And so actually it may be the end of this one, but it's just the beginning for some others that you could create. So here's another example, Marilyn Monroe. So she left her estate to her acting coach. And so all of the assets transfer to him. He dies. His third wife inherits all this money, and that's somebody that Marilyn Monroe never even met. So had she had a trust, you know, she probably could have said, I want to provide for my acting coach for his life, but at his passing, maybe I want my charity, my church to get this, or even somebody I know to get this. And so, you know, as you're thinking about your assets and how they're going to transfer, and is this really what you want, and, you know, maybe you want it to go one step further, not just outright. So we've talked a lot about, you know, funding your trust, you're thinking about your trustees. So one thing to think about is, you know, why would you look at a corporate trustee, a corporate fiduciary versus an individual? So there are some advantages to using a corporate fiduciary. You know, corporate fiduciaries, they do this every day. They are familiar with this process, and they are used to handling all types of assets. So collectively, the staff has a lot of experience and a lot of resources. You know, they put their full attention into asset management, and we are regulated. Corporate trustees are regulated, so we're held to a higher standard than an individual that we should know. And a lot of courts, you know, turn to corporate fiduciaries as an expert. They're reliable, so the corporate fiduciary is not going to die or move away or anything like that. And corporate fiduciaries also, they follow the document. You know, they're fair and they're impartial. You know, you may have an individual that, you know, is not going to have that objectivity. So, and like I mentioned, that the trust officers work with attorneys and CPAs, and we have that financial planning team for our clients. So we have those resources to draw on that an individual may not have. And I think maybe one of the most important ones is that you have peace of mind, you know that you have somebody that's going to administer, and you're your trust and that you're going to keep peace in your family. You know, you name one child and the other children are going to think they're doing it all wrong. And, you know, so you kind of have that independent party to keep everybody friendly. And, you know, it just relieves the burden too, I think, from family members or friends or somebody that you could name. You know, there's a lot of responsibility with stepping up and being, you know, a personal representative or a trustee. And so those are just some reasons. So some takeaways today, and I know that Jennifer and I talked a lot of information in 40 minutes, and, you know, there's we could probably go on forever, but some things we want you to take away is, you know, you really need to pay attention to how your assets are titled and to know how they're going to transfer by how they're titled. And is that what you want? You know, estate planning is not just for wealthy individuals. You know, everybody accumulates things in their lifetime. Everybody has an estate. And whether, you know, it's naming a beneficiary as your plan or relying on state statute as your plan, you know, not everybody needs a trust, but you just need to know that what you want is what's actually going to happen. You can tailor it to your individual goals. And, you know, we've seen a lot of stuff in our years of being in the business, and you do need to look at it every 5 years, get with your professional team. You know, sometimes when we have clients come in, I have them just leave their document and I read it and I say, don't tell me what you want. And then when they come back, I say, this is what it says. And sometimes they say, oh, that's exactly what I want. But sometimes they're like, wow, that is not what I want at all. And that's the time where you need to go contact your attorney and look at updating this. So, and the bank, you know, we do provide that service. If people, I mean, there's going to be questions, we're always available for anybody that wants to call. Like I said, we have a lot of trust officers in our department, and we'd be happy to answer any questions. With that, I'm going to ask Andrew and Thomas to come on up here, and we're going to throw them to the wolves now. But we will be happy to take questions.
You just have to unmute it by holding.
Yes. Do we have a microphone?
Will this presentation be on your website or somewhere where we can review it?
Unmute it right there.
I think that they're working on doing that. Greg, do you know? Or Gary? Yes.
Is there a certain amount of time in Wyoming when a will is out of date?
No.
That's
Can you hear me? Yes. Okay. Think about it like this. You could prepare a will, execute a will, primary beneficiary of the will dies the next day, it's out of date. You could prepare a will, it's good for 20 years, never goes out of date. So facts change, situations change, your documents need to change.
There's a lot of questions.
I know. How about the gentleman in the pink there?
Or red.
Or red?
Jennifer did something out of transfer on death.
So what it is, it's a deed, and it's effective upon your death. So in the deed, you actually recite, I so-and-so convey my property effective on my death to whomever you want it to go to. When you pass away, you file an affidavit in the real property records, and then by operation of law on that affidavit, the property passes to your beneficiary.
Yeah.
You mentioned if you have a trust, but in the Michael Jackson example, that he had a trust that wasn't funded. I don't know, I'm not clear on what that means.
Do you want to take that or you want me to?
Either way.
So once, you know, you can have a trust and you sign it and you have it in place, but it's kind of like, think of it as a bucket. Unless you take the assets and you put them in the bucket, so you have to fund it. You have to change title. Your house is a good example. Take it out of your name, put it in the name of the trust.
That makes sense.
Yeah. Did you have a question?
I did. I was executor for my parents' estate in Nebraska. I live in Wyoming. I guess I was surprised, if I understood it correctly, that the executors had to be Wyoming residents. Our children who live in Oklahoma and Texas right now are co-executors on our will. That is not legal in Wyoming?
It can be, but there's mechanisms in the statute. So you can have an out-of-state person serve as a PR. However, there needs to be supervision with an in-state person. Does that make sense? So you would have to appoint,
They still have to be executors,
but you would have to have a co-personal representative, like Hilltop maybe would do it, or something along those lines. They just by themselves could not serve. They would have to get someone in-state who's a resident to serve along with them.
they can get that through Hilltop.
Well, I don't know if Hilltop will do it or not. An entity like Hilltop or any Wyoming resident could do the job.
Could a corporate fiduciary take the place of your children in other states? If you had a corporate fiduciary, it would negate whatever you have previously done as far as children.
Yeah, so that's typically how it goes. So you'll nominate, let's say you have 2 kids, you nominate each kid to be the PR or trustee of your will or trust. If neither one of them can serve for whatever various reasons, maybe they're not in state anymore, you nominate a corporate fiduciary as kind of a stop-all, to where somebody will be able to do the job. Whole point is we don't want to have to go to court, petition the judge to appoint somebody we don't know, or we may know them, but we just don't want to go through that process. So if you name a bank, then the bank is always going to be there. You're always going to have a PR or a trustee.
That corporate one would need to be in the state.
Correct, yeah.
Good too.
In the event that you create a revocable trust and you have your documents all taken care of, you fund your trust, then do you just hold that trust document in your safe deposit box or someplace that's accessible to your successor trustee? Or does it have to be registered with the court or the?
No, yeah, and you're absolutely right. You put the trust somewhere safe. We always tell people safe deposit box, gun safes, things of that nature. We also recommend you tell your family
successor
members or
trustee where
whoever
it
is going to
is.
be the trustee where the document is.
Right.
And so,
But
and how to get
never-
into it.
But it never has to be filed in a court.
Nope, it's 100% a private document. So until the settlor or grantor passes away, nobody ever gets to know what's in it.
Okay.
The only thing I might add to that is though if it's a will that you're putting in your safe deposit box. So you okay. Thank you. Do you have a question?
Our life insurance policy is in our trust. So the trust is the beneficiary, and then you have the first beneficiary. But what I'm not sure, then our son, one of our sons is the second, but if Kelly, if he dies before me, then I can't collect those monies off the policy?
Well, it depends how it reads. If the trust, yeah, so the question is she has a life insurance policy where the trust is named as a beneficiary. So how that would, those get complicated, but how it probably should read is the then serving trustee of your revocable trust dated such and such is the beneficiary of this policy, right? Then when you pass away, the money is distributed to the then serving trustee of your trust, whoever that is. The trustee then takes that money and then distributes it out pursuant to the terms of the trust.
So if there's one survivor, and that trust is going on, and that those monies are distributed by the trustee?
Right, so if you named your trust as the beneficiary of the policy, your trust gets the cash, and then the trustee distributes the cash pursuant to the terms of the trust.
Yeah, okay, that's what I thought.
Thanks.
Yeah, is that better? Oh, that's way better.
Any question here?
What constitutes a legal will?
A legal will in Wyoming, well, there's two. So you can have a holographic will, which you can handwrite a will, so it's handwritten by you, signed and dated. That's legal. The other will is a will signed by the testator, witnessed by two individuals. And that's what it takes.
What actually goes through probate? I mean, some things did and some things didn't. Could you please?
Yeah, so
clarify that?
the general, or your general assets in your probate is, what assets are in your probate estate? So what assets are subject to probate? Assets which you own in your individual name. If I owned a house as Thomas Shaner, I pass away, you got to probate it. I own an investment account as Thomas Shaner, no other beneficiary designations, you got to probate it. Assets you don't need to probate, joint tenancies with rights of survivorship. When the one tenant passes away, property passes to the surviving tenant. Things like life insurance, IRAs, 401ks, bank accounts with death beneficiaries designated, pass pursuant to the contract, so you don't need to probate it. What else is there?
The difference between a trust though and a will.
So here's why the trust, you don't have to probate it. So in Wyoming, in most states, a trust isn't a legal entity which holds title to property. The trustee of the trust actually holds legal title to the property. So like take me for example, if I conveyed my home to Thomas Shaner, trustee of the Thomas Shaner Revocable Trust, when I pass away, there are no assets which Thomas Shaner owns. Thomas Shaner, trustee of his trust, owns the asset. So we don't have a probate estate.
I have a trust set up, and I have a piece of property with my stepdaughter in Denver, and one in Indiana with a friend, and they're both joint tenants. What happens if I die? Do I need to get those into the trust?
So say that again, I didn't catch the second part.
I have my trust is all set up, but I have two pieces of property, one in Denver, and I'm joint tenant with my stepdaughter. And then I have one in Indiana where I'm joint tenant with a friend. Never put them in a trust, and I just wondered if I die, what happens?
They would go, or it's rights with survivorship? Yeah, they would go to your stepdaughter and your friend.
No probate?
No probate.
We've got a revocable trust set up, and all of our major assets are in the revocable trust name. But some of our, all of our checking accounts and savings accounts have built up, have our daughter's name on it. They're in our names, but they have our daughter's name on it. My question is, are those checking and savings accounts subject to court proceedings? Say my daughter should get a divorce or something?
Well,
Is our money acceptable by the courts to our daughter's name being on it?
well, I'll give you the lawyer answer on this one. So the question is they have a bank account, the daughter's name is on the account, or the daughter has some rights to the account. Is that subject to court proceedings, probate, or whatever else of the kind? It all depends. Is your daughter just a signer on the account? Does she have the ability to write checks? If she has no legal title, no legal ownership to the account, then the answer is no. Well, no in one regard and yes in the other. If she's not on the account, then that account would be subject to probate. If you owned it in your individual name, not as a trustee of your trust, there was no joint ownership with rights or survivorship, that's a probate asset. But let's say she got a divorce. She has no legal right to the account. It's not hers. All she has the ability to do is write a check. Her soon-to-be ex-spouse wouldn't have any rights in a divorce proceeding to go after those accounts.
But if she was an owner on there,
Right, so, but if she was an owner, so let's say she was an actual owner, held 50% as joint tenants with rights of survivorship, then you would skip probate, but then there would also be a claim in the divorce proceeding, so.
What about paid on death, if you put a child on your checking account, paid on death, POD, how, does that just go into the child, the checking account?
yeah, it'll transfer at your death to the,
Can you repeat her
yes, her question was if she listed a POD, a payable on death, on her checking account or savings account, how would that transfer? And at her passing, it transfers to the beneficiary listed on that designation, but the beneficiary does not have access to those funds during your lifetime. In the back?
So what determines the difference between ownership and a
reliant on the bank paperwork?
Yeah, that's correct. So you're actually going to have an account title, and the account is going to say who owns it. Then it'll also say so-and-so owns the account, but then this other person has the right to write checks or whatever they have to do.
Oh, sorry.
We can't hear you. If I couldn't read this, I wouldn't hear anything you said all day.
Is this better?
Hold it really close,
Okay, I'll try it like this.
like you were taking a drink.
Okay.
Everybody knows that.
Question here?
If you have multiple real estate properties and you want those properties to be managed for different beneficiaries, is it advantageous to put them in multiple trusts or cover them under one trust?
Can everybody hear me now? Okay. So the question is, you have multiple properties, and you want different beneficiaries to have it. Do you put them in one trust or do you put them in multiple trusts? Once again, the answer is it all depends. You can put all the properties into your revocable trust. Then on your passing, the properties are distributed out to individual trusts set up for the benefit of certain beneficiaries. You could set up trust during your life and convey the property to the trust for the benefit of each beneficiary. It's really a fact-dependent situation, and you just come up with a plan, discuss it with your attorney, and really can't give you a better answer than that one.
On the same line, if you have a property and you have, say, a sibling, and you want that property to be available for their occupancy, but not for their ownership or not for their heirs, is that a viable situation?
Yeah, 100%. So you could say in your trust agreement, well, you can do it a lot of different ways. You can have you could give it to them for their life. Upon their passing, then it goes to whomever you want it to go to. You could put the property into a trust where the trustee is given the authority to allow a certain individual to remain in the property, pay for that person's expenses with regard to the property. Then upon that person's passing or upon the person moving or whatever circumstance you want to tie to it, the property is then distributed to where you want it to go to.
That can be included with other properties in one trust.
That's correct, yeah.
Are there any other questions? Well, we thank you all so much for coming, and we hope that we provided some valuable information and things for you to think about. And
Thank you.